I'm Christy Harshbarger with ISAC, and I appreciate everyone taking the time out of their day to be here with us. Today, we are talking about pipelines and county's role in that construction process. And we've got John Long here with the Office of Consumer Advocate for Iowa to talk to us. And I will just be handling things mainly on an administrative side. So just a couple of notes about that. This is being recorded and we can share that later with you or anybody else in your office that you might want to see it. And if you have any questions, we'll try to address those as they come up. And if you just want to pop those in the chat, we will keep an eye on that. And with that, I will turn it over to John. And John, thank you so much for being here today.
Thank you. I have my presentation on the screen. I would like to present to you about the role of counties in these pipeline cases. I hope to explain each of the things that the counties are statutorily required to do if these pipeline cases proceed. And I'll explain that one of the things our office, the Office of Consumer Advocate, gets to do in the case is propose conditions on the permit if it's approved. And one of the things we want to learn from you are ideas for conditions that we could propose that would help the counties with the things that they have to do. I've heard anecdotal reports that during the Dakota Access Pipeline process, there were challenging issues and areas of confusion for counties. So if we can, we will try to get those addressed and think of conditions that we can ask the board to impose that will help the counties. I did receive from ISAC some questions that came in before the meeting, and one of them was, what is the timeline for these cases? And I have found some slides that we have three companies. We have Summit was the first, then we have Navigator, and then we have Wolf. And we don't know exactly what the schedules will be. That's been an issue that we've been debating. We asked the board to delay setting a procedural schedule in Summit because we wanted more information available so that people would know as much information as possible about any eminent domain claims. We also wanted information about their safety and safety response plan and modeling available before a schedule was set. The board did tell them to provide some of that safety and safety response plan information now. The board didn't address all of our concerns and say that all of the eminent domain documents would have to be produced before a schedule would be set, but they did say that it's too early now to set a schedule. But I'm now going to put up on the screen. Are you seeing the projected timeline screen? No, you're not. Got to figure out how to share. Okay.
Sometimes there's different options for share screen or share tab.
Right. We'll come back to that. I can put the tentative schedules that the companies would like to see up later. For now, I guess we'll just proceed with my, do you see my first slide?
No, I think you have to reshare your screen.
Okay, there, do you see it now?
Yep, we do.
Okay, this is some background about our office. Our office is established by Iowa Code Chapter 475A. The Consumer Advocate heads our office and is appointed by the Attorney General and confirmed by the Senate. Our office has a staff of attorneys and technical staff. including engineers, accountants, and economists. We also have the ability to hire outside experts, which we are looking into for these cases. There's a list of duties that our office is to perform provided in 475A.2. I think the most relevant one in cases like these pipeline cases, I have it up on the screen. It says, act as attorney for and represent all consumers generally and the public generally in all proceedings before the Iowa Utilities Board. And so that is, it's in fulfilling that duty that we want to reach out to the counties and learn what sticking points will be for the counties in fulfilling their role in this case. So I'll
Hey,
move
John.
on.
Sorry to
Yes.
interrupt you. We're not seeing the slides advance. We're still just seeing the first slide.
If you click advance or from beginning on the tab up at the top of the PowerPoint.
Do you see this? Do you see the duties slide now?
No, I think you might have to reshare your screen. I have it pulled up on my computer if that would be helpful, and you can just tell me when to advance.
Okay.
Do you see that okay?
Yes. So if you could advance to the next slide. So in these pipeline cases, we're going to review the materials submitted by the pipeline companies. Also all the objections. There have been a lot of objections and comments from the public, including from representative of counties. We're reviewing all of those. We get to conduct discovery, meaning we get to send what we call data requests, which are questions and requests for documentation to the companies, and they have to respond. And then we get to submit our own evidence and testimony. We will have our experts, which will be people in our office, and we are talking to, we are looking into getting outside experts that can help us with these cases. And then at the hearing, we will get to cross-examine witnesses, and of course, we'll get to submit legal briefs. At this stage, we don't have the evidence that the companies have to present. We'll look at what the statute says they have to prove, and that will be an important next step in the case, is us seeing the companies making their case. So can we go to the next slide? All right, so this shows the overview language, which is the introductory paragraph to Chapter 479B. It tells you that the legislature intended to grant the Iowa Utilities Board the authority to implement controls to protect landowners and tenants from environmental and economic damages which may result from hazardous liquid pipeline construction, and to approve the route through the state. So next slide. So this is from 479B.9, and it describes what the board must find if it were to grant a permit. And it says the board has to determine that the line will promote the public convenience and necessity. And the first part of this clause is important. The board can impose conditions or restrictions. And that's what we want to hear from you in ways that will help the county. If we go to the next slide. Here is a quote from the board's order in Dakota Access, and the board described what it considers the public convenience and necessity test to mean. The board explains that they consider it weighing the public benefits of a proposed project against the public and private costs and other detriments as established in the record in the case. So I want to make one point. The public convenience and necessity test is whether the board will grant the permit. There's still the constitutional issue of whether it's a public use for constitutional purposes, and that would determine whether or not they can constitutionally have the right of eminent domain. We do know that there are a lot of very serious concerns about eminent domain use in the case. I don't have slides on the eminent domain issue, but I did send to ISAC, and I assume it was sent out, the Iowa Supreme Court decision in the Dakota Access case. In the Dakota Access case, people challenged the public use, and again, getting to the issue of whether or not they could use eminent domain. And several of the objectors to the line said, well, there's no oil production in Iowa and there's no oil refineries in Iowa, so there's no on-ramps or off-ramps of the pipeline crossing Iowa, and so that means it can't be a public use. The Supreme Court didn't buy that. They said, well, Iowa is a very heavy user of liquid fuels, and moving this crude oil across Iowa to refineries will help that market. So there is a public use. The court did say that it rejects sort of I think the court used the term trickle-down economics, that benefits just of, well, it's sort of injecting money into the economy. The court said that it isn't going to consider that to be good enough. So that's something to keep in mind as we look in this case. Can we go to the next slide? Again, 479B.9 authorizes the board to impose conditions and terms. For example, in Dakota Access case, our office said, look, if there's a bad oil spill, it could require a lot of money to clean it up. And the LLC that was created to run the oil pipeline may not, if it's bad enough, they may not have enough assets. So we want the large oil companies that are the parent companies to guarantee any financial obligations of the pipeline LLC. And we asked the board to require the parent companies to sign parental guarantees protecting the Iowa public in the event of a spill, meaning that the parent companies would have to come in and pay if the LLC couldn't, in the event that there were damages to be dealt with. And the board agreed with us and required those parental guarantees. So that's one of the things we can do. That's one condition that's come up in another case. And again, we want to hear about the role of counties. We know that some of the counties affected by these pipelines were also involved in the Dakota Access, so we definitely want to hear from them. If there were things that the counties have to do in this process that can be clarified or made easier. If it imposes risks on counties, perhaps counties are concerned that they could get dragged into litigation. We want to know about that because we can think about conditions that we could ask the board to impose that would protect the counties and help the counties. Can we go to the next slide? So in this slide, I explain the board's authority is to apply the public convenience and necessity test and decide whether the line gets to cross Iowa and to consider the route. And it can also impose terms and conditions. There's some limitation in terms of federal preemption. The Pipeline Hazardous Materials Safety Administration, known as PHMSA, is responsible for ensuring safety. And so PHMSA and not the Iowa Utilities Board has final authority over safety. There's a gray area in that the board can still look at routing and could, for example, say, we don't want the line to cross here because there's too much risk, so we're going to order you to route around it. On the other extreme, the board couldn't say, you have to use a higher grade of steel when constructing the line to protect us. That is more clearly federal, but routing the Iowa Utilities Board can get into. And so obviously, some of the things you're going to look at in routing touch on safety in terms of the impact of if there were a leak or danger to people around the line. Can we go to the next slide? Okay, so this slide talks about the two main things that the county is specifically told it has to do in these cases if they proceed. One is the county inspector, and I believe that I think counties are probably already aware of that obligation, that they have to appoint an inspector. They don't have to do it now, but I do know from calls I've received from county people that a lot of the counties have, and we've seen filings where the inspector is named. During construction, there's to be an inspector on site at all times, and the inspector is to see that the agricultural restoration plan and all other conditions that the board imposes, as well as, and we'll talk about this in a bit, private agreements about restoration and routing on a private parcel are complied with. If they're not complied with, the inspector can temporarily halt construction and go to the county board of supervisors and recommend that the county supervisors take the matter to the Iowa Utilities Board for corrective action. We'll talk in greater detail about that in later slides. And then the second thing is construction damage claim. At the conclusion of construction, the county declares that construction is complete, and then landowners who believe that they have damages from the construction of the line can bring their claim to the county. The county then I think the statute tells them, the county supervisors, to send it to the chief judge of the district court in the county, who would create a damage compensation commission. And I want to make another point, that is separate from compensation for eminent domain. This is talking about damages. So potentially even someone who voluntarily signed an agreement could have a damages claim. And then eminent domain, obviously, as you know, the process in Iowa is that the County Compensation Commission determines what the value of the taking is for compensation for the taking, but damages from the construction process would be things like crop damage, damage to anything else on the property. A big one, obviously, is drainage tile. Okay, next slide. So here's a little bit more detail about the county inspector process is dealt with in 479B20. So the county is to appoint an inspector. The inspector is to be on site for all construction activity. The inspector can temporarily halt construction. The inspector refers issues to the supervisors, and the supervisors can petition the Iowa Utilities Board for corrective action and/or civil penalties. And this is important. The pipeline company is responsible for the reasonable costs of the inspection, which means the pipeline company has to pay the costs of the county retaining the inspector. I know from Dakota Access case that some of the counties, I think the overwhelming majority of the counties named an engineering firm, but some of the counties I do know named the inspector as someone from the county's engineering staff, and then that person's time, the cost of that person's time spent working on the pipeline project could be billed to the pipeline companies. And I want to think about that because the statute specifically tells us that the counties are to be compensated for the cost of the inspector. I just think it would be beneficial if you would all think about other demands on county resources, whether it's concerned about counties getting drawn into legal proceedings or anything else that could take county time or money. And we could potentially recommend to the board that a condition of the pipeline be that the pipeline companies reimburse the counties for these things.
Hey, John, we did have a couple questions come in. One I think you might have just touched on, but to ask for some clarification, they're asking if the pipeline pays for the county costs for the inspector to be on site at all times.
Yes. Let me go to the statute. So it says all cost of the inspector So 479B20 says that the inspector is to be on site at all times during construction. And a separate section says all reasonable costs of the inspector shall be paid by the pipeline company. So I'm not aware that there were disputes about, but if there were in the Dakota Access Line disputes about counties getting paid for this, then we want to hear about that. But my interpretation is that any costs incurred by the inspector are to be paid by the pipeline company.
And then the other one has to do, I think, with the petition point and point 5, although a little bit different. Is the county required to file a petition to intervene in order to participate in the utility board hearings?
Well, I would say traditionally, yes. If you want to fully participate in the hearing, meaning submit your own evidence and witnesses and cross-examine, then yes, you should file a formal intervention. But I would pay attention to what the board does when it sets the procedural schedule. The utilities board could say that sort of counties, typically landowners, particularly landowners who are subject to eminent domain claims, do not need to specifically intervene. They're automatically a party because of the eminent domain claim on their land. The board could include counties in that and could say, well, we're not going to make counties intervene. But in cases with the Iowa Utilities Board, testimony is pre-filed, almost sort of in a court case like an expert witness report. It's all pre-filed, and then the hearing is not for that witness to recount everything he or she said in their testimony, but simply to be cross-examined by the other parties, and the board asks questions as well. So practically speaking, I think for now, if a county wants to be actively involved, I think they should plan on filing an intervention. But I would watch. We don't even have a schedule. So in the schedule, the board will set a deadline by which you have to file an intervention, and we don't even have that at this time. So, and it's possible that the board could make special provision for counties or other government entities.
We had a couple more questions pop up too. So if the pipeline is not constructed, will the cost of administrative work done as county inspectors still be paid?
Let me look exactly at the statute again. Well, it says the reasonable costs of the inspection shall be paid by the pipeline company. So again, I don't know how the rubber met the road in the Dakota Access case. I don't know if there was preliminary work that the inspector did before actually going on site for construction. I don't know if Dakota Access balked at paying that, and we would definitely want to hear about that. But I think that's definitely a risk, and maybe something we should put forward is that potentially the company would say, you know, don't even send us bills from the inspector until construction has started. And if that's a problem for counties, then we would definitely like to hear about that.
Yeah, somebody had a question too that maybe kind of goes along with this. Can counties require contracts to be signed first for the inspector costs prior to construction beginning?
A contract with the pipeline company, I presume?
I'm thinking that's what they mean, yeah.
Well, we want to hear more about this. I mean, I know that many of the counties are already naming the inspector. I'm not sure what work the inspector would be doing at this stage. But if counties have concerns, we would definitely want to hear about it and potentially say something to the utilities board about it. I don't know what's actually happening, and if the inspectors have work that they have to do now. I don't know. I mean, I think the statute seems to envision that the work really begins for the inspector when construction starts.
Yeah, it looks like I'm hearing from a couple folks that there's some administrative work to be done ahead of time. So file setup, landowner lists, meeting with the landowners.
I think it's reasonable to ask for that. We will take a note, because as I mentioned, 479V20, if you look at subsection 3, it says that the inspector, if the inspector determines that there's been a violation of the standards adopted under this section, which that I think primarily refers to the rules of the Iowa Utilities Board about agricultural restoration, the land restoration plan, or any independent agreement on land restoration or line location. So that clause tells me that there could be some advanced work for the inspector to do, because if the inspector is to enforce the terms of independent agreement on land, I'm interpreting that to mean, say the company comes to a landowner and says, can we have an easement? And the landowner says, well, I want you to use these special construction techniques on my land or at this location on my land. And let's say that the company says fine, and it's embodied in the easement agreement documents. This seems to be saying that the inspector is supposed to enforce that as well. And for the inspector to do that, he or she has to know about it. And so one of the things I was thinking is that potentially, and I'll have to look in Dakota Access if the board already thought of this. If they didn't, or in any event, we could say the board, as a condition of the permit, needs to require the pipeline company to give sort of a packet of documents on every parcel that's going to be crossed ahead of time to the inspector, which would include any private agreements about how construction or location is to be on that parcel. But obviously the inspector needs to know about it if he or she is going to enforce it.
We've got one other question that came in about inspector costs. Is there any reason a county should enter an agreement specifying the maximum amount of reasonable expenses with the pipeline company? I'd say that'd be hard to determine, but I'd be interested in your thoughts.
I don't know. I'm speculating that maybe the pipeline companies are trying to cap it, or is the question more that when you engage an outside engineering firm, that your contract with them caps? A lot of times when we engage outside consultants at OCA, the terms of our contract will be sort of not to exceed. I don't know if you need to do that if statutorily you're entitled to all reasonable costs from the inspector. I am aware that there's a practical issue and there may be a delay in the counties getting reimbursed. And we want to know about that and think about things we can do to the Iowa Utilities Board to make that happen. Because we don't want a situation where a county has to go out of pocket and then wait a long time to get paid by the pipeline company.
Yeah, so there was a follow-up comment on that. The person that had that question said the company wants their maximum obligation capped.
Well, I'm glad we're having this meeting, because we weren't aware of that, and that doesn't sound. I don't understand why they would think that's appropriate.
And then we had another question come in that I think I've heard in another meeting that you've talked about. This is something that needs to be explored. But if the inspector stops construction, does the county become liable for delay of construction costs, standby, etc.?
Well, this is a concern to me, because just reading the inspection statute and going through the Dakota Access case, which I did, in Dakota Access, it was made clear that the landowners have the right to be on site during construction. And so I anticipate that that's going to be a very stressful job for the inspector, because you're going to have the pipeline company that wants to get done as fast as they can, and they're probably going to be quite aggressive about it. And you're going to have the landowner that has concerns, and they're both going to be right there. And so I'm worried about potential for, I don't have a definitive answer. I don't know if other statutes make counties immune. I would assume that there's some kind of sovereign immunity, that if the county is, well, I don't want to give an opinion about this because I don't know exactly how liability can attach to a county. I would hope that there's some protection in law that when the county is fulfilling its role that the statute says it has to do by having an inspector, that it can't be sued. But one of the things we could do is a condition is just say, there could be a couple conditions that I'm thinking of. One is the pipeline company would agree to pay any litigation costs that the county incurs because of this. And that could include whether the pipeline company, even if they're not seeking damages, if the county tries to halt, or if the county inspector tries to halt construction, I would anticipate that the company would go to court about that. And so even if they're not seeking damages, the county would presumably have to appear in court and explain itself. And if you're a big county, I don't mean to pick on, but Polk County probably has plenty of attorneys to send to court, but a county that has very few people and a part-time county attorney, that could be a problem. So one of the things we could ask, and there's another side to this, that a landowner could say, look, you were supposed to have halted construction and you didn't. Like I said, this inspector is going to be in a really tight spot. So I would not want that job. But so either way, the county could end up somebody complaining to court that the inspector did something he shouldn't have done or didn't do something he should have done. So potentially we could have a condition that says the pipeline company has to pay all litigation costs of the county. And I'm just throwing this out there. I don't know if it's I can't promise that there's not some other provision of law that says we can't do that, but it's something that we would really consider. And then another thing, I don't know if this is even necessary, but we could ask the board to, as a condition of the permit, say that the pipeline company waives all liability claims against the county. And again, I don't know if that's even necessary, because I don't know if other provisions about sovereign immunity just sort of make clear that the county would not be liable for fulfilling its official duties through the inspector in this case. But potentially we could just ask the board to say, as a condition of the permit, you waive all liability claims against the county.
Yeah, I think when we have this conversation with a group of county attorneys, there is a lot of debate about how some of those liability claims might play out, and the idea that even if the county didn't have liability, just the cost of having to defend the fact they don't have liability. So we'll both keep that one on our radar to the person that asked that question.
All right. Have I covered the questions you've gotten so far, or should we continue with our slides?
Well, it's up to you. Let's see. I've got several. I apologize that my phone keeps ringing. I have got several coming through. So it's up to you if you want to go through some more of your slides, and then maybe we can circle back to those questions.
I do want to get to these questions because I've already learned something important.
Okay.
I'm a little concerned that one of the pipeline companies is trying to cap its statutory obligation. So that's something we're going to want to follow up on here at OCA. So this is important to us. I do want to get back to it, but I want to make sure I get the presentation out there, and then we can get to questions. So can we go to the next slide? Construction damages claims. That's the next thing that 479B tells the county that it has a specific role in and tasks to complete. This came up in Dakota Access. I want to hear from the counties. There was some delay, and I think the Iowa Utilities Board had some concern that the statute indicates that when construction is complete, the county is to issue the certification saying construction is complete in our county. And only then can damages claims begin. I believe the statutes, well, I think it says within, it has to be at least so many days after the certification before you can bring damages claims. And that's again in 479B30. And so I don't know if in Dakota Access, some of the counties were slow to do this because they just didn't understand exactly what they had to do, or if there were other concerns that I'm not aware of, which was causing them to delay. But I do know that the board issued some orders sort of telling counties to, be sure to certify when your construction is complete. So the next point in this slide says that landowners can make claims only after the county certification, and it's not less than 90 days after completion of construction. A landowner whose land was affected may file with the Board of Supervisors a petition. And so then the Board of Supervisors, the statute doesn't have the Board of Supervisors determine the damages. The Board of Supervisors are directed to submit the claims to the chief judge of the district court in the county to appoint a compensation commission. And then this, I mentioned this simply because this is the only mention I can find in the entire statute where the county attorney is specifically mentioned. I mentioned this when we talked to the county attorneys. 479B.30 sub 3 sub B says the county attorney may assist in consolidating multiple damages claims. And it also goes on to make clear that if the county attorney assists with that, he or she is not acting as an attorney for any of the landowners. It's just an administrative function. But that's I don't personally understand the way practically I see it happening is a compensation commission is created and then each individual claim comes before it. I don't really understand the statute talking about having to consolidate claims, but it's in there. Did we have any questions on these damage claim process?
I haven't seen any come through.
Okay, can we go to, okay. I also, in this slide, I'm talking about some ongoing things that the county has to do. Subsequent tiling, 479B.31. So I read this statute as saying that if, say, 5 years after the pipeline goes in, a farmer decides that he wants to upgrade or install, because he hasn't previously had it, or do some work on his tiling. And the fact that the pipeline is in the way is going to make it more expensive to do that work. And my read is 479B.31 says the pipeline company has to pay that extra. So if a farmer, a landowner wanted to do some tiling and it gives a role for the county, it says the county engineer is to provide, quote, written verification of the additional cost. I wish I had more specifics for you, but I don't. I don't know if you would just break that down by the contractor for tiling says if the pipeline were here, it would cost $50,000, but because it's here, it costs $100,000, and then the county. I don't know exactly how the county engineer is to figure out what the additional costs are, but this statute is making clear that for the benefit of landowners, in my read, the pipeline company, it's recognizing that changing or installing tiling systems after the pipeline is in the way, that pipeline could cause it to cost more to do that. And this is making clear that the pipeline company has to pay that extra cost. And then the last point is reversion for non-use. I'm not going to get into specifics because this seems kind of remote, but the statute states that if, let's say they get the pipeline and they operate the pipeline for 10 years and then they announce that they're ceasing operation. These easements are for a specific purpose, which is to operate this pipeline. And so if the purpose the easement was created for is not being fulfilled anymore, then there's a process to I think, basically clear the land title of the easement, and the county recorder would have a role in that. Next slide. Well, we've talked about this in all these tasks that the county is faced with, and anything else. I mean, I understand that the counties are probably getting contacted a lot. Any challenges the county has or foresees, we really want to hear about, because, as I said, we can tell the utilities board to do something about it in how it orders, if it proceeds. I also want to make this point. I don't want anyone to think I'm saying that we're going to support the line. We're going to review them, and we have concerns, and we're going to do our investigation, and then we'll testify. But I'm trying to think ahead for if these lines proceed. We don't want it to be any more difficult or burdensome for counties than it has to be for fulfilling their roles in this process. So that's why we're talking to you. And I think this is my last slide, in which I asked for any other questions.
So we've had a couple from before to cover, and then a couple new ones come through, if you're ready for questions.
Sure.
Talked a little bit about the tiling. So we did have one question come in. So sometimes county supervisors are also the trustees for drainage districts. And so there's a question about if that changed their role in this process at all when they're acting in that capacity.
I think the question is that basically the county commissioner sort of has multiple hats, and one is county commissioner and one is as an official for the drainage district. I don't know. I would refer that to the county attorney to see if it changes. I can say that I do recall drainage, and I don't know that they necessarily became a party in the Dakota Access case, but there was input and comments at least filed by some drainage districts. Obviously, drainage is an important issue, more or less so depending on which part of the state you're in. But I understand that these drainage districts are there. The bottom line is that if the pipeline is damaging this drainage, then the pipeline company has to correct it and pay for it. I do know also from going through the Dakota Access case that in the view of a lot of landowners and some of these drainage districts that, some of these drainage systems are more work of art than science, and it's very difficult to repair them after the fact. So you want to protect them from damage as the construction is happening. And we understand that and want to hear about that as well.
Let's see, then we had questions. Can the IUB require that inspectors hold landowner meetings in each county before construction begins, and that the pipeline companies reimburse them for those costs?
I don't, the example I have is Dakota Access case in 2014 and 15. And I don't recall that happening or even being suggested. It's something we can consider, and I can take back to the attorneys and staff who are working on these three cases and see if that's something we propose. I'm just trying to think procedurally. We would want to hear more specifics about what people have in mind about that, because I'm assuming it would be closer to construction, and once these cases get going more, but if the person who asked the question or anyone else has something more specific, we'd certainly want to hear about it.
And the next one was, do you know when IUB will release the landowner lists?
Right. That I think is being litigated in court. So the Sierra Club the Iowa Utilities Board obtained lists of the landowners that the Iowa Utilities Board said it needed to do its process of preparing for and hosting the information meetings, which we've had. Although I think we're going to have another round for I think Navigator is adding some counties, and Wolf has to have their information meetings. So there will be some additional information meetings in some counties. Sierra Club asked for it. The board did what it typically does, which is the company has asked us to hold this confidentially. We go to court, and the court decides whether it's public or not. And that is still ongoing. I know that our office has been involved in the court case, not me personally, but another attorney here. And our office took the position that there isn't really a reason to keep them confidential, and that they should probably be made public. But I don't think we have a decision from the district court on that.
Okay. We had another question come in about the idea of reasonable costs. And if it's viable, if we want our hired inspector at all times and a rep from the engineer's office around waterways, roadworks, etc. Is that a reasonable thing to ask for?
Well, I mean, I'm not, I guess I can't specifically, I guess ultimately the Iowa Utilities Board has to decide whether it's reasonable, but I can say it's been done. The board made allowance and requirements that Dakota Access deal with the road authorities for damage to roads. So I think that it sounds reasonable to me, and it's something that has been addressed before roads. And on waterways, I assume, I'm not sure I fully I'm assuming it's that debris could be washed into the waterway during construction or that kind of work. And so you'd want to watch to make sure that that doesn't happen. That also sounds reasonable. I specifically remember the road issue coming up.
Yeah, and we did have a question about that too, so maybe I'll just tie that in. I've heard concerns about damage to county roads where the pipeline is not constructing in that county, but their equipment will be transported on these roads. Is there anything about restoration, repair, or placement for these roadways?
I know that DOT deals with these companies and these construction projects. I can't think specifically of a county in Dakota Access that wasn't on the route, but it sounds reasonable to me that if their equipment is damaging your road, even if you're in a county that's not on the route, it sounds reasonable that they should be responsible for that. And there may be laws outside of the sort of laws that we deal with that empower the Iowa Utilities Board. There may be laws that DOT has that, you know, that protect roads and anyone who's damaging.
And then we had just kind of a general question. Do you have any advice for counties that are concerned about some of these things that we don't know yet, how they'll play out? Any advice on how they might resolve those before construction begins?
Well, first, contact us. I think my contact information is, if it's not on my slides, we can definitely get it to the participants. We want to hear what your concerns are. And then second, watch the dockets. More information will be filed. The board will set procedural schedules. Sometimes the board talks about specific issues and sets a timeline for when the company has to address specific issues. Ultimately, the company will file its main batch of evidence for the case, and they'll deal with a lot of things. And then I guess a particularly concerned county should consider intervention. That would give them discovery so that they wouldn't necessarily have to wait on filings and react. They could ask questions to be answered if they were made a party. There's a caveat to that we typically, I don't have a legal answer. I can just tell you what practice is. We aren't doing our discovery on these companies. We typically let them file their case first, and then we ask them our questions. I don't know that there's a legal standard that says you can't sort of jump the gun and start questioning them now. We try not to, and I think some of them would respond that they don't need to answer you right away, but I don't know how that would play out.
And then we had a question, I think that, is a pretty common one. So under 479B.5 through 7, the pipeline had to address how the pipeline must fit with its local zoning and land use regulations. Are counties able to enforce local zoning regulations, such as requirement for obtaining a conditional use permit? And then what are the conflicts and limitations by state and federal law for the counties to have more restrictive zoning requirements?
Right. So recall that we had a slide where I sort of explained OCA's role, and I mean, part of this is within OCA's role. I mean, and part of it is sort of outside of it. I mean, we don't have any particular expertise or sort of statutory authorization to be giving legal advice to counties about ordinances that they may have. That said, we do get to tell the board what conditions we think there should be on a permit if they proceed with this. And that's something we would want to talk about, is what should the relationship be between the board's order and local zoning and permitting and ordinances. And we could end up making a recommendation that sort of all that local ordinances have to be complied with. And I don't know what ordinances would really be in play. I mean, I guess just general zoning, but I'm not sure. And it also does get into a potential, I suspect it might end up being a legal issue in this case, and that is, does the board preempt the counties or does it not? And I don't know how the board would even answer that. I know that in other cases, the board has been fairly deferential to local standards, and you'll see it in generation siting cases for like wind and solar, where the board will say you have to comply with any local requirements.
Let's see, we also had a question about, is there any requirement for a decommissioning bond? So if the pipeline at some point is no longer being used.
I'm not aware of that being specifically in the statute, but if it's a concern, it's something that we could consider, recommending. I believe in Dakota Access case that was discussed, and I think Dakota Access agreed that what it would do if it ever stopped using the pipeline was it would give the landowner a choice, and it would say, do you want us to just seal off the line and abandon it in place, or do you want us to come in and remove it and then restore the land? And that makes sense to me, because some landowners may say, I'd rather not have you open a trench again. And some may say, I want it out of here. So in Dakota Access, I think it was that the company just agreed that it would give the landowner a choice. But in terms of establishing a bond, I don't remember that was done, but it's something we could think about.
Let's see. I saw a question. Is there a way, it looks like counties are getting multiple contacts from one of the pipeline companies, asking them to fill out forms and asking for information. Is there a way that IUB can require all of this communication to go through one county employee for each pipeline?
Well, that's, again, we want to hear about burdens this is imposing on counties, and that sounds like a live one, that the burden of information requests from the companies. We will talk about that here. I'm not sure if we would file something with the board and say, can you establish a process about how this happens? The other point I would make is you don't have to go through us. If a county is having an ongoing problem because of this pipeline, it can file something with the board and complain about what's happening. And if it has a specific solution, it can ask the board to implement it.
Let's see. Who addresses the safety setbacks needed for residents and livestock and routing the pipeline? Counties are required to provide updated emergency response plans.
Right. So this was a round of, this relates to a round of filings that we've had with Summit, and the board responded. We told the board that, so my understanding is that PHMSA requires some study documents from the pipeline company about modeling what would happen if there was a leak and a response plan for safety and public safety that the company has. Unfortunately, my understanding is that PHMSA does not require those documents until 60 days prior to operation of the line. And so OCA, our office, is concerned, we need that information in our case with the utilities board, and PHMSA's timeline may not work with our case, because presumably they would go through a case to get a permit, and then their construction process would be a year or more. And then 60 days before they're about to turn on the pipeline, they would file this with PHMSA. Well, we need it now to consider routing for the board, and it sounds like counties want it too. So we told the board that this information is necessary before these cases even proceed. The board delayed on some of it and said, basically it'll consider it as we start moving forward in these cases. But several of the items they ordered Summit to file related to some of these things. So we would like to hear from counties if there's things that they want to know now about safety and modeling. I mean, that's an obvious example of what counties could think that they want to do in terms of local ordinances, is like how far away you have to be from people and livestock. And again, I'm not answering legally whether they can do that, but I understand that that's something counties would want. And in order to do that, you'd want information. And this is such an unusual and new type of pipeline that, we were able to find resources about oil pipelines, and sort of the risks are more documented. But with carbon dioxide, it sounds to me like it's very sort of mile by mile specific about the terrain and the atmospheric conditions where you are, about what happens if there's a leak and what distance away people would be in danger. So at this stage, we've just been making the point to the board that we need this information in the record in this case. And it sounds like the board is in agreement with us on that.
We are pushing close to our 2 o'clock time. I know we got a few more questions, but one was a reminder to see if we could pull up that schedule for the different cases before IUB.
Okay, I'll go back to sharing now. Let's see.
And then while you work on that, I've got a couple admin ones for folks that hopped on late. So yes, we will be recording this. We can share that with attendees.
So do you see my timeline now?
Yep.
So this was filed by Summit, and you can see the file stamp. It was filed in, they filed the information meeting slide deck that they presented at the public information meetings. You can see that it's old. I mean, it's almost a year old at this point. It was filed September 1st of last year. And they show you, this is nothing blessed by the Iowa Utilities Board, and certainly not by us, but this is what the company wants, or said it wanted in September of 2021. So, they're showing you their timeline there. And I did email that to ISAC for each of these companies, so we can do that. And now I was going to move off of this one onto the next, to the Navigator timeline, if that's okay. Okay, now do you see it says anticipated project timeline? So this is Navigators. And again, this was filed by Navigator November of last year. And we're not aware of anything updated that the companies have said about what they have in mind. But this is what Navigator has in mind. I'll just leave it up there for a little bit for people to look at it. And can I switch? I have a slide deck from Wolf where they have their timeline. Can I switch to that?
Yeah.
Can I switch to that one now, Christy?
Yeah, please do.
Okay.
And we can get these sent out to all the attendees as well, so they have it.
So this is, do you see project schedule?
Yes.
Okay, so this is from Wolf. I've found something that they put out. It's much more of a thumbnail sketch from Wolf, but this is the only thing I could find where Wolf tells us what time frame they have in mind.
All right, we had one more question come in of kind of a different topic. So I'll ask you that one, and then I think we'll end with that. Has IUB considered the issue under 479B.15 on what actually constitutes a service by certified restricted mail? And when does IUB consider service to actually be complete?
Well, the other attorneys in our office were handling that, and I do know that that was the subject of some filings with the Utilities Board. And I believe this relates to notice for entering for surveys, and I've heard reports that it was getting fairly controversial in some areas. I believe that the Iowa Utilities Board issued. I will check and send you. There is an order where the Iowa Utilities Board discussed this. I'll wait for the actual document when I find it and send it to ISAC. But I believe that the board said, referring to some court decisions about notice, that essentially all they have to do is send it certified mail, that a person refusing service or failing, if they get a little slip saying, this is at the post office, you have to come sign for it, and the person never goes, that still counts as service. And I believe that the board referred to those court cases and sort of endorsed that view of what is and isn't service. But I could be wrong. I think that's correct, but I'll find the document and I'll email it, and it can be sent to all of you.
Okay, well, if for some reason we didn't catch your question today, feel free to reach out to myself or John. And John, again, thank you so much for your time and expertise and engagement on this issue. We really appreciate it. I'm sure we'll continue to be having these conversations.
Right, and I just want to end with this. We definitely want to hear issues as they come up from counties, but I understand that some of these things could be urgent And you don't need to wait for us. You can go straight to the utilities board if there's a problem. If, for example, I guess the example that was mentioned that the companies are sort of overwhelming county staff with information requests, and you'd like some kind of streamlined process. You know, I can't give you an in advance answer about what the Iowa Utilities Board will do, but you can certainly take those concerns to them, and you can just file in the case.
Great. All right. Well, thank you again so much for your time, and thank you everyone that was listening in and all your great questions. We appreciate it.
Thank you.